Hello, everybody.
And Mr. Scott, let's keep continuing. So I guess the first question I have is, and there was an accident, but no injury, and there was a no insurance way, I guess they gave a warning. And give me just a moment. I don't sentence people to jail I got your note. I don't sentence people to jail for fines and costs. It's not lawful for a judge to do that, by the way. I can issue a warrant if I give people an opportunity to do other alternatives. In your case, we would do an alternative. And they'd fail to do it and don't want to do it or just ignore the court, But really what I would do in your case, and we can talk more about it. I want to hear from you what you would prefer, because I have some options. But if we reduce the balance to community service, it would be 12 hours. And are you still in the Temple area?
Yes, ma'am.
I have a list of places that are automatically friendly to community service calls from just anyone. And they need the help, especially this time of year. And we can just reduce your fines and costs to a 12-hour sentence of going out in the community to a nonprofit organization and collecting those hours. I have a pre-approved list. I have a way that if there's something you want to do, we need to make sure that I am allowed to accept those hours under state law. So it has to get pre-approved if it's not on my list. I work with people on that. So if we do that, we do a 2-week check-in for anything that you're trying to get pre-approved. If you're not doing that, if you're just using the list I provide, you don't have to take that step. But all the hours would be due in 30 days, which is, so the first deadline would be 1/14. The second deadline would be 1/30. And that's called your final due date. And I have a form if you're trying to get a place approved that isn't already approved on my list. Will this work for you?
No.
No. Tell me what's up.
I mean, with all due respect, man, I'm not gonna do no community service for running no stop sign.
Okay.
And it's crazy at my young age how they say we're speeding, but most of the people who got a speeding ticket are older, and I haven't got a speeding ticket in my life.
I don't find that most people are older.
Most people in this call are older, and they got it for speeding.
So your fines and costs are 234. It's not a speeding charge, it's a stop sign charge. And I did receive a plea of guilty. Is that your plea at this time?
Yes, ma'am.
Okay. So I have listened, but I don't feel that I can order payments. I don't feel that, and I have two choices, payments or community service. So I am going to order community service.
I'm not doing that, man.
Well, I understand that, but I'm still going to order it because that's my order of the court. And the order of the court isn't a consensual thing. It's not something where I say, do you really like this order? It's
Oh, y'all finna come pick me
I'm
up?
going to go ahead and I'm going to mute you because you're talking over me and I will listen in a moment. And I'm hearing you. Yeah, he hung up. So 12 hours due, 1:30:25. He refused and hung up. So, but just send it to him and maybe cooler heads will prevail. If not, and he's listening, you can go ahead and earn a warrant and we'll take you to jail eventually, but it's not going to happen overnight because I need to give you an opportunity to calm down and maybe do something that's appropriate for your circumstances. Okay, moving on. Yes, sir, of course. I always try to accommodate where I can. Even you missed the person yelling at me a moment ago, so that was fun.
Oh, wow. Okay.
It's not fun. I'm joking. I'm being facetious.
I understand.
I don't enjoy it, but I'm not going to change my tune. I'm just going to stay respectful and even
Sure.
and just, wait it out. But a lot of pro se people, and this is a frustrating time of year for folks, especially when you're talking about money with them. And People are also sensitive if they feel like they did not do anything, and that's understandable. They have the right to their feelings. We don't have the right to just any level of expression we choose, but
Right.
he pled guilty, but he was yelling that I needed to just come pick him up because he wasn't going to do anything I ordered. So that will eventually probably happen, but we'll see. Hopefully.
Right.
What I just did was ordered community service because he doesn't have the money to pay it. We're going to email that all to him, and maybe cooler heads will prevail, and he'll still have that opportunity, even though he yelled. Not going to take it out on him. That would be wrong. So I've got 20. I know you can top me, Mr. Alcazar, but I've got 25 years of law, and I still go home at night, and I just take a deep breath, and I don't take it all home with me. So
No, I understand.
yeah, you've gotten there too, I'm sure. I mean, those first couple of years of practice, everything feels so personal, but it's really not. People are just where they're at.
Good morning, everybody. We're ready to go?
Yes, we are ready at the jail.
All right, Folz. All right. First is Folz, and then on deck is Brown. This is a child abuse, scores of 7. What does the state feel is appropriate?
Thank you, Your Honor. Your Honor, the state's requesting $15,000 bail with no 10% cash option, DAS with daily testing if she posts. Ms. Folz scores a 7 on the risk assessment. However, she just pled no contest to possession of a controlled substance, 42 to 100 grams of meth, on November 18th, and she has sentencing set on January 8th. She had multiple violations while on pretrial supervision, including positive and missed tests, an arrest out of Carson City, and then this arrest. She also has in 2024 misdemeanor arrest for contempt on October 14th, and then a misdemeanor arrest for contempt on April 4th. And then in 2023, she's got a felony arrest for possession of controlled substance, 14 to 28 grams out of Carson City with no disposition. So, Your Honor, clearly she's not going to comply with conditions. She's on pretrial supervision right now in her felony case with sentencing set. The stakes honestly couldn't be higher. Now the state's going to be free to argue in that case. So for those reasons, the state is requesting the $15,000 bail with the no 10% cash option and DAS with daily testing if she posts.
All right, Beth.
Thank you, Your Honor. Ms. Foltz is unable to afford any amount of money bail. Regarding the charges in this case, her children have been placed in the protective custody of Human Services Agency. There's a hearing on Friday the 3rd regarding that ongoing custody. Because the children are no longer in the home, and she will be needing to comply with the conditions imposed by the family court. In addition to these conditions, we would ask for an own recognizance, understanding that she does have the sentencing coming up, and as the state indicated, the stakes are very high for her to appear for all of her future court appearances, both in this court, the district court, and in family court.
All right. Well, unfortunately, the state has shown by clear and convincing evidence that bail is necessary. Well, the defendant's recent behavior has shown that bail is necessary to ensure the safety of the community and the appearance of the defendant. Therefore, to be set at $15,000, random drug and alcohol testing, DAS supervisional bail laws, make all court appearances, comply with CPS, and will allow her to be OR'd either through IAP, residential, if for some reason that district court gets continued out, or if district court sentences defendant to probation. 3 ways out: post your bail, go to residential treatment, or if you're able to convince district court to give you a chance on probation, then you get out. Otherwise, we'll see you January 8th at 9 a.m. for your arraignment. Brown and then Torri.
And Your Honor, we would ask to waive Mr. Brown's appearance.
All right. What is the state feels appropriate for bail?
The state's requesting for Mr. Brown $15,000 in DAS with testing. He previously scored a 6. This is an ad book. He pled guilty yesterday to possession of drug paraphernalia. He's also got that PMP hold. In, 2018, he's got a felony arrest for parole violation and then a felony conviction for sex offender failure to register. And then in 2000, he's got that underlying offense. He was sentenced to life with parole in that case. And then he's got a misdemeanor conviction for failure to register back in 2000, then additional older misdemeanors and a felony conviction for PCS in 1988 and a felony conviction for sales of a controlled substance in 1990. The issue, Your Honor, is obviously Mr. Brown admitted that he hadn't registered because he was on the run from P&P, presumably from the supervision that stems from that underlying conviction. So obviously he's a flight risk. Obviously he's a risk of continued criminal conduct. So the state is requesting that $15,000 bail.
All right, that's,
Your Honor, we'll submit on the bail this morning.
all right. I do find by clear and convincing evidence that bail is necessary to ensure the safety of the community and appearance of the defendant will be set as requested, $15,000 DAS supervision. Oh, bail laws make all court appearances January 8th at 9 a.m. for the arraignment on the criminal complaint. Torri and then Smith. We do have a victim here on Torri, I believe. Domestic battery, strangulation, prevent, dissuading, false imprisonment, battery with a deadly weapon, domestic battery first, scores of 3. What does the state feels appropriate?
Thank you, Your Honor. So I would just note first, Your Honor, based on the facts that I see here, I won't be charging the battery with a deadly weapon. So the bail I'm requesting, the 10%, the no 10% cash option doesn't apply unless Your Honor feels otherwise. But the state is requesting $3,000 bail, no contact with the victim, no firearms, and that is all. I know, so that Your Honor did indicate the victim is present. She did indicate to my office that she would be present. She told us that she doesn't want a no contact order, and she's not afraid of the defendant. But the issue I see with that is that on the danger assessment, she marked yes to all of the questions. And then specifically for has the defendant tried to kill you, she says 1 year ago after breakup, talked about slamming the car into the tree and slicing me with a sword. And then has he ever threatened to kill you? And she marked every day. And so there's this discrepancy that's frankly very concerning to the state, given the facts of this case, the multiple instances of choking that are alleged here. And so for those reasons, the state is requesting the $3,000 bail.
That's
Thank you, Your Honor. We will be requesting an own recognizance release, even if the victim is not requesting a no contact order. The court could certainly impose that as a way to mitigate concerns for her safety and ongoing concerns. We were able to speak with Mr. Torri's father, who is also a witness and indicated in the probable cause and an attached witness statement. Mr. Torri lives with his parents and would return to that residence. He's supported by the family and does some additional odd jobs, confirmed his phone number, and has family support to make sure that he attends all future court appearances. He has not been in trouble before, so there's no indication he would fail to comply with any conditions or miss, future court appearances. I don't have all of the details, but Mr. Torri's father indicated that he had left some things out of his initial statement and was following up with officers to supplement the report that he had given. So we would submit that the state has not met its burden by clear and convincing evidence that there are no less restrictive options than to impose money bail for Mr. Torri.
all right.
And Your
Ms.
Honor,
Davis-
the victim would
Go
like
ahead.
to speak to
Yeah.
the court.
Ms. Davis, go ahead and unmute yourself and you can tell me whatever it is you want to tell me.
I just want to say I love him a lot and he's not a bad person. Our relationship is just somewhat toxic, but he's not a bad person. I just want to say, please don't let this define him as a human being. I promise you, he is such a kind man with a good soul and he loves me dearly. It's just, we argue a lot and his anger in our relationship hasn't been the best the past few months, but I promise you, his anger just got the best of him that day. He would never hurt me this bad. And I know that if he got out, he wouldn't do it again. But I really don't want a no contact order because I do love him and I don't want to stop talking to him. That's all I have to say. Thank you.
So, ma'am, I have a few questions for you.
That's fine.
Does he own a gun?
Huh?
Does he own a gun?
It's fake. It's not
So,
real.
yes.
I would say if you want to say it like that, yeah, but it's not real.
And Your
Has
Honor,
he
if I may,
ever-
just on that point,
It's like on
on his
his
criminal history, he did apply. He did a background check to get a firearm and was denied.
it's like a fake
And-
gun with the orange tip.
Okay. This strangulation choking has occurred before.
What'd you say? Sorry, I cut out.
I said the strangulation choking has occurred before.
Sexually wise, yes, that's when I consent, but he's choked me before once, literally only one time in an argument.
Okay. And I understand your difficult position. You love him. I just have a difficult decision to make too. And so,
No, I get it. I get it.
right, I just need, that's why I'm trying to go over the answers to these questions that the prosecutor mentioned that you answered yes to. So you're not saying that you check those yes boxes by mistake. You're just saying you love him, you think he's a good person, and that doesn't define him.
Yeah, it doesn't. It's just we're very toxic. I've been with him since I was 15. So he's had to deal with childish me and he's had to deal with mature me. And then yesterday we didn't sleep. We were up all night playing the game. So he was running off with no sleep. And then I was pissing him off and it got way out of hand. And it shouldn't have. And part of that is my fault too. I'm not defending him or anything. I'm just saying he's not a bad person. He's a good man with a kind heart. His anger just gets the best of him. And I tell him he needs to get that in check.
I understand. Well, I want to thank you for being here. I want to wish you the best of luck in the future.
Thank
With
you.
regard to the decision I'm presented with, it's a difficult one. I will say I'm not going to set the bail that the state requested because I think the defendant's going to make it. And I believe you're in or you're out because there's no evidence that posting money bail does anything to ensure the safety of the community or the appearance of the defendant. Something we're going to have to address that we've addressed in the DUI cases with the use of the DUI rand is the danger assessment. And some people know, anyone involved in when we got the NPRA, that I had indicated that this is what we needed. We needed a specific violence predictor or danger assessment on these types of crimes. It's something that many of the pretrial tools have built into them, like the PSA court, and ours doesn't. And generally, the violence predictor is accurate in the validation studies of the pretrial tools that use it. There are some domestic violence assessment tools that frankly, the evidence is inconclusive. But the questions that are on this danger assessment are for the most part the same that are on the violence predictor of the PSA court. So I'm presented with a standard risk assessment of whether he's likely to show up, and it looks like he's likely to show up according to the NPRA. Then whether he's likely to reoffend and whether he's likely to engage in violent, dangerous behavior, especially towards this victim. And if 11 out of 11 answers are yes, there's not a higher risk that danger assessment can contemplate. So I'm faced with a tool that says he's a great danger to harm this victim. And I have the victim who's in love with him that says that he's not, but the evidence says that he is. And unfortunately, we know in domestic violence cases, somewhat like DUI cases, that the crime occurs again and again and again before an individual is arrested. We don't have the arrest on this circumstance, but we do have the evidence in the sworn probable cause sheet and in the danger assessment that is consistent with that. So that's a long way of me saying that unfortunately, and I do say unfortunate in this case and the previous case, because I think the majority of the people should be out. I think I'm constitutionally compelled. That's our system, and we over incarcerate folks, especially when they're presumed innocent. But how do I have a danger assessment that says 11 out of 11, highest danger assessment possible, and release somebody on their own recognizance or on a nominal $500 bail? The cash that they could post. And so unfortunately, I will say again, I have to set bail at a high amount. because the state has shown through the evidence presented, including the danger assessment, that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and appearance of the defendant. So we set it at $50,000. No contact with the victim, separate criminal offense pursuant to NRS 178-445 for the maximum 120 days. Ankle bracelet in place before release to ensure compliance. No firearms. Check out with DA's order. Bail laws. Make all court appearances. January 8th at 9 a.m. for the arraignment on the criminal complaint.
I love you all so much. Be safe, be well, sleep sweet, and much love.